Hello and welcome to today's webinar, Bringing Class Actions and Mass Claims to Resolution. This webinar is proudly sponsored by the Upchurch, Watson, White, and Max Mediation Group and the University of Florida Levin College of Law Institute for Dispute Resolution. A note to our attendees. Your microphones are muted. However, if you want to ask a question or make a comment, you'll notice at the right-hand side of the screen in the middle is the chat feature, so you can type your question or comment. Those will not be responded to during the presentation, but our presenters may respond after the presentation is concluded. Also, if you look at the top right corner, you'll see an orange arrow or circle, depending on your computer, which will allow you to minimize the GoToWebinar dashboard. Our presenters today are Rodney Max and Steven Jaffe. Rodney Max has been mediating for more than 26 years. He has mediated in 34 states as well as Puerto Rico and the District of Columbia. Among the variety of cases Rod has handled, approximately 50% of his practice includes class and mass actions. In the class action area, Rod has mediated hundreds of cases, including state and federal statutory remedies, advertising and branding issues, products liability issues, privacy and security issues, and consumer issues. In the mass action area, Rod has handled dozens of cases involving catastrophic injuries and damages caused by explosions, aviation accidents, pharmaceutical issues, medical malpractice issues, and multiple vehicular accidents. Rod has spoken in many national forums on the topic of mediating class and mass actions. Steven Jaffe has been practicing law for 34 years. Before joining the Upchurch Group, Steve was co-managing partner of Farmer Jaffe PL, an AV-rated law firm. Steve has been AV-rated for over 20 years. He has served as lead counsel, co-counsel, or co-lead counsel in class action cases throughout the United States, yielding relief to class members valued in excess of $2 billion. Steve has been identified in Best Lawyers in America every year since 2013, including Lawyer of the Year 2013 Class Actions Plaintiffs in the South Florida region. I'm Jeff Fleming, your moderator and a shareholder, mediator, arbitrator, and special magistrate with Upchurch, Watson, White, and Max. And now we present Bringing Class Actions and Mass Claims to Resolution. Gentlemen.
Thank you, Jeff. We appreciate that introduction, and I look forward to working with Steve, with all of those who are listening in. And this is a topic that's near and dear to us because it has uniquenesses from other types of mediations in the litigation field, personal injury, wrongful death, commercial cases. When you get into class actions and mass actions, these are more public than other cases in the ultimate, and therefore it requires a sense of process that in turn requires a sense of patience together with a professionalism that goes with each person that gets involved. And so as we deal with this in a civil and ethical approach, the first I want to talk about is confidentiality. And that confidentiality, I think, there we go, confidentiality throughout the process, which certainly begins in the very beginning. We send out confirmation letters that set out the parameters of mediation, but everything from that confirmation on requires a high level of confidentiality because we're dealing with issues that otherwise from both sides, and Steve and I are going to be stressing throughout this process, mutuality of every point we're making. Mutuality, plaintiff side, defense side, has got to have a level of appreciation. And in the world of confidentiality, what's the sensitivity on the plaintiff side? Well, as those of you on the plaintiff side that do this, you know that you don't want other people knowing that you've got this case going on. You don't want the competition in other jurisdictions while we're mediating. Let's get this done. Let's get it approved. Let's get it filed in court before anybody else is there to take the good work you've done and put it in other venues. From the defense side, there is high value in what's being done. The world does not need to know this, and the competition that the defense has is very, very sensitive. Are they going to agree to this or not? And as long as we can take this position that nothing is agreed until everything is agreed, and while that process is ongoing, confidentiality stays from start to finish until you're ready to file with the court. What we usually will have is a confidentiality agreement. Not that it isn't in the rules, it's there, but for everybody, all participants, not just the lawyers, but every participant in the mediation will sign off on confidentiality. And therefore, we all understand that we are protected, and we have the opportunity to work through each of these elements without anybody knowing about it, any court, any other attorneys, any other competition in the world. When I say competition, I'm talking about other businesses that may otherwise be interested in what we are doing, don't. So confidentiality is probably the hallmark and one of the most important things that protect us and give value to this process. With that, I think we go into the foundation. Steve?
Thank you, Rod. Good afternoon, everybody, and thank you for joining us. Rod and I thought it was a topic that we should at least open up to the people that would like to hear us speak on this, because we think that we have a view on how to best obtain results at mediation, and obviously it starts well before the mediation begins, because as Rod said, it is a process. And so what I want to talk about is preparation and communication as a foundation and a basis for negotiations. It's a general thought that I have, and it's been borne out over the years, and that is that three issues need to be worked through in order to properly settle a case. And these issues should be discussed and vetted and looked at from the second the case walks in anybody's office, both from the plaintiff or the defense of the case. And that is, number one, law and the facts. Seems pretty common sense. What are the facts of the case and how is the law applied? And the second one is what is being demanded and ultimately what is going to be offered. And then the third one is emotion. And we want to address all three of these because the better you unpack these three items, the better chance you have to be successful at mediation. Emotion generally is something that I have found, and surprisingly so, is a large part of a case, whether it's the plaintiff who's bringing the case or the defense who's candidly upset that they're being sued. But emotion needs to be addressed. Emotion needs to be discussed. Everybody needs to be able to vent. But truly, the best mediation results come when emotion is removed from the equation. It allows us to focus on the law and the facts portion, and then ultimately on the economics. So my point is on law and facts, before any plaintiff files a case, they certainly should be prepared to address a motion to dismiss. As soon as the defense is involved in the case, they should be looking, obviously, at the problem areas in the plaintiff's pleading and anticipate where they want to go in their motion to dismiss. They should clearly, everybody should be discussing these issues with their clients. I found that the more communication that the parties have with their respective clients, the better off everyone is and more prepared. And then finally, the money. The demand needs to be based on the facts, on the law. If someone comes in and demands, astronomical amounts of money that aren't based in law and fact, that's just going to be a stumbling block. When it comes time, if there is, you get through the law and the facts to make any offers, those offers need to be consistent, again, with the law and the facts. And as long as the parties come with those attitudes and have done their exposure analysis, the better off we can move towards the act of actually going into a mediation. Rod?
That takes us into the preparation, as Steve alluded to, where we have an opportunity to get a handle on the parameters. That's not done on the day of mediation. if it's not done before the mediation, then the mediation is going to be a difficult journey. So what we will typically do is when this mediation gets confirmed, we'll try to set out a calendar of, all right, if the mediation is on day 30 of this particular month, when do we need to engage? Some we can engage 2 weeks before, some we can engage a month before, some we may need to engage 2 months before. But the point is that before we get to the table, there is work to be done so that the mediation itself can be more meaningful. In talking to both sides, the idea of identifying the issues, what's agreed upon and what's not agreed upon. And one of the themes we will have in each of these is nothing is agreed till everything's agreed, but let's at least identify those points that are for now agreed upon so we can look at those things that may be problematic. In addition to just the issues, during pre-mediation, we need to identify who the leaders are. On the plaintiff side, is there a group of lawyers, or is there a combination of law firms involved? Is there 1, 2, are there 3 people that need to be the leadership? Maybe everybody. We're not exclusionists, but the question is, what is effective, not just within that group of plaintiffs' lawyers, but with the defendants? And then when you go to the defendants, the idea of who's in charge. We know that there's clients behind this. Many times when you're dealing with class or mass actions, you're dealing with in-house counsel. Very important. They have a very important role. They don't own the company. They're just the legal team inside. And of course, there's a legal team outside. Again, the idea of identifying the leaders and, before we get to the table, connecting up with those leaders. Sometimes in pre-mediation, the idea of bringing leadership from both sides together to have a conversation can help clear the air on the structure of the mediation. What are going to be the parameters we're going to work on? What do we need to focus on? What do we not need to focus on? In pre-mediation, identifying the interests of the parties. And this is something that even in the context that Steve brought up before, the idea yes, we have rights here. There's liability, there's damages, issues that have got to be dealt with. There's defenses, there's affirmative defenses, there's procedural, there's substance, but there's interests. And the hallmark of mediation, in addition to confidentiality and the various aspects on which it's founded, it is interest-based. And if the idea of let's see what those interests are. Again, if you can identify them before the mediation, more meaningful for the mediation itself. And these communications are done by calls, mediator picking up the phone, setting up, coordinating a time and enough time to talk through. This is that 15 minutes, is it a half hour, is it an hour? That needs to be done on each side, and sometimes it's even bringing people together. Once in a while, we've been involved in mediations where we'll meet with the plaintiffs, we'll meet with the defendants, we'll meet with in-house counsel, we'll meet with representatives, vice presidents, chairman of the board, whoever would help to break the ice before you get to the table may be helpful. And I will tell you through various experiences, it can be critical to understanding not just rights and even interests, but the personalities that are involved, because those personalities are going to drive this. And of course, at the end of that is setting an agenda. It's not just about a number, it's a context of a number. And so are we going to deal with substance or are we going to deal with structure? Maybe we have to deal with both. But let's have an agenda that we can agree on and approach that mediation. The more we can help you as lawyers be the leaders of each of your sides, the better it's going to be for you, and then ultimately the better for the success of the mediation.
So, Rod, before we move on, let me just add something before we move to the mediation. I would also add that pre-mediation the time is well spent managing client expectations. Again, it goes back to communication. I'm a firm believer that we should set expectations early, and the best way to do that is to really educate the client. And again, from the defense perspective or plaintiff perspective, really digging into the law, the facts, and just make sure that the client is fully up to date so that their expectations on what either side may demand or where offers may be, they have full knowledge well before the mediation, and that's why the pre-mediation calls, and as Rod said, the pre-mediation meetings, if the case warrants it, are very, very important. And I would also advise people to control your evaluations early. All clients want to know evaluations. They have set parameters on when evaluations are due. I would encourage lawyers to be as detailed as possible and keep their clients highly up to date, so that when we mediators come in and we have these pre-mediation conferences, we're able to go through these issues and these items, and they've already been vetted in great detail within everybody's respective camp. Okay.
Very good. That takes us into the mediation itself. Steve, did you want to say anything preliminarily on that?
Just when we think about a mediation, from a class mediation or a mass action, as mediators, we want to discuss in our mind issue sequencing and how we're going to run the actual process. Not every mediation should be run the same way, and I know people would say, well, yeah, well, they always are. Well, maybe they are, but some of us understand that maybe they shouldn't be, and each one is different depending on, as Rod said, the personalities and the facts and the emotions of people. So these things we think about before we come into the mediation room. Rod, go ahead.
And Steve's exactly right. And we all know this. There are class action and even mass actions where at first you've got to get by, is this going to be a class action? Or is this going to be an individual action? That may need to be discussed. If it's not, let's put it over on the side. But if it's not, let's not ignore it, because it'll get in the way. The idea of, as we talk about the merits of the case, do we need to really discuss the merits of the case in terms of who wins and who loses various issues? Maybe, because if we're before a summary judgment, most of the time we see ourselves either after a motion to dismiss, sometimes before, but the idea of if we need to talk substance, let's do what we have to do. But if we don't, my encouragement is, can we get beyond individual versus class or individual versus mass? Can we get into the structure of it? Because if we get in the structure of it, the structure can help us deal with the merits. In other words, what the amount we're going to give per claim, the type of claims process we're going to have, the type of notice, that will all be affected by the merits of the case. So we're not ignoring the merits. We're not ignoring the substance, but things like definition and scope. Sometimes people say, well, Rod, we already know that. And my statement is, good, I'm glad we know it. Let's use it. Have you talked to the general counsel yet? Have you talked to the CEO or the CFO who's now going to be at the mediation? Because if you haven't, I'd like for them to hear a reasonable approach to it. We're trying to build, in addition to the merits that we're trying to get to, the resolution, they're about people, and we got to build rapport. We don't start with trust. We have to evolve the trust. And in evolving the trust, it's about people getting to know one another. Many times in mediations, you hear me talk about things other than just the merits of the case. I want to talk sports. I want to talk about a movie. Just to get to know, who are we dealing with? What are their buttons? Everybody's got one. And if we can understand people, then we can make more progress. So let's talk about definition scope, just to get ourselves through it. Some people say, hey, we've already got that done. Court's already ordered it. Let's talk about the type of relief we're going to be getting into. Is there a non-monetary component? Sometimes non-monetary components can help us in what I'm called building the bridge. Maybe the answer is no. We don't need any non-monetary components. Sometimes non-monetary components can be helpful. Yeah, we've already changed what the issue is here, and we'll put a value to that change, but let's talk about those changes just to make sure we're all on board before we get into the money. The money is going to be the heart of this thing, and as you see on the what's in front of you on your computer, Sometimes I even skip over monetary to get to things like notice and administration, because again, kind of easy things, but it helps build the bridge. Nothing's going to be agreed until everything's agreed, but let's take one step at a time across this bridge and build commonality. And if you find things between definition and scope, notice, administration, commonality exists. Now, maybe some of that's been done before the mediation and you can skip your way through that. But in the issue sequencing, these things need to be addressed because it is all a part of a context of what we're going to do. And then getting to the meat of it, the idea of the monetary remedies, to the extent that they are relevant to the conversation, it's not just about a number. It's about what's the context. Is this a claims paid process? Is it a claims made process? What type of claims made process is it going to be? Is there going to be a non-reverter or is there going to be a reverter? Not only are we dealing with the personalities in the room, for those of you that we've been mediating with recently, I know many times it's the personality of the judge that we're dealing with. So that too comes into play. And so your experiences with that are very critical. And then obviously you've got things like cypre, and at the very end, we're talking about incentive awards and attorney fees that sometimes take a mediation in and of itself. It's the unique mediation that can get done in one day, or you get a direction to it, you get it done within the week. Those are unique. Many of them take 2, 3, 4 weeks or months. And you just got to hang in there and keep the process alive. Steve?
Yeah, I wanted to just add to this before we move on to the second phase. Is the best lawyers I've seen handle mediations are the most prepared lawyers. I think lawyers get in a little bit of a rut when they just come through and walk through the process. I would encourage lawyers to look at mediation, especially in class action and mass action, as mini trials, because as I'll discuss in a little bit deeper detail later, the better you can discuss and debate the law and the facts, the more you'd see from either side that there's going to be less and less conflict. There's more agreement as to the posture of a case than parties generally think, but only if both sides have thoroughly vetted their case, thoroughly prepared their case, know the deposition testimony, and then obviously as it applies to the law, the facts apply to the law. That way you can then have a risk analysis discussion, and many other areas can be discussed that we will discuss in a bit. But that's it for now, Rod.
I'll say this, the one thing that Steve brings to mind is that within each room, there may also be a mediation going on. You've got inside lawyers, outside lawyers, CFOs, CEOs. Now, we had it before the mediation, the pre-mediation, we tried to learn about them and learn about those personalities. Now we're dealing with them. And there may be a mediation within the mediation that we've got to deal with. And so the question is, when I start a mediation, I like to have people in separate rooms so I can get people, A, more comfortable about their own surroundings. B, we can talk maybe individually and separately about, what's going to happen as we begin to go into discussion of these details. And then as you go into caucuses, and as they will turn the screen from issue sequencing to caucuses, we have joint sessions. But the idea of maturing into those joint sessions is a matter of understanding who we've got in the room and the politic of each room. In a mass action, and I want to maybe focus on that just 1 second to say that mass actions everybody's got their own individual set of cases. Pharmaceutical cases, back in the 90s, we had breast implant cases. We have insurance policyholder cases in the 90s. You've had an array of different kinds with automobiles or other type of vehicular issues. You've got people all over the country that have come together with somewhat unique issues, but how common are they? And those issues need to be worked out within each room to get us the chance to have a joint session and then the separate caucusing that we're going to talk about. So as we emerge into caucuses, I would say that's going to be a matter of the strategic way we want to handle this. Do we remember I talked about, do we need to deal with substance, or we need to deal with structure? If it's substance we have to deal with, we'll do it. If we can move on into structure, as we've defined before, that too. We're looking for bridge building. So, and joint caucuses, I'll just say one more thing, Steve.
Sure.
As mediator, we have a leash on this. Is the leash a long leash, or is the leash a short leash? If there's as Steve identified emotions before, it may be a lot tighter of a leash than it would be if there's a good rapport building. Good rapport building, let's keep building it, and that joint session can go as long as possible. When it gets to a point where there are negotiations on any particular issue, from monetary remedies to notice issues, then we'll separate you and go into separate caucuses. Steve?
So before we go to caucuses, I just want to, if we could, so these slides were put up for a reason. When we, as mediators that handle class actions and mass actions, think about or go into a class action mediation, we look at it as two phases. The phase one, as Rod has discussed, are issues that we need to work through. Each line item needs to be worked through in the mediation process. I think it's important, if we end up making progress, that we also are looking to phase two, and that is confirmatory discovery. If we can reach agreement on A and B, well, what do the lawyers need to do from a discovery standpoint to make sure that they are comfortable and have adequately represented the class, to make sure certain things that have been agreed to are in fact true and or being carried out. Certainly, in the mediation, you better be thinking about the approval process and whatever steps are necessary to obtain approval, because you need to know things like the district and the local rules. You need to know your judge. You need to know, as an approval process, is it a state class action? Well, the approval process in a state class action is different than a federal class action. And what I mean by that is, generally speaking, in state court, it's a little smoother, a little easier of a process. You need to understand that lodestar versus a common fund analysis regarding the reference to attorney's fees and what jurisdiction you're in. You want to obviously work through this phase one and phase two, because ultimately you want a really good, tight term sheet, because the term sheet will then result in a good settlement agreement being drafted, and all material terms should be dealt with at the term sheet level. I think people always want to rush through at the end. I propose do a detailed term sheet at the mediation. It saves time in the long run, and you're in the room together, and I would encourage parties to make that term sheet as detailed as possible in the room, because it's amazing what happens after everyone leaves and the little nuances that are then began to be fought over. Rod, we can move into caucuses now that we have now set the parameters. Now it's time to actually get to work.
Well, and as we talked about the joint process before, you do have the separate caucuses. Steve, you want to address that? You're more than welcome to.
Sure. So the joint caucuses, I just want to say this as a thought. I'm not so sure that opening statements in these type cases are needed. I think if you have good pre-mediation conferences with counsel, I think that the opening statement phase of a mediation is less and less necessary. I think it begins with an adversarial position, and as Rod had mentioned, we are trying to build bridges. So I am one that advocates for waiving of opening statements in these cases, but that's just my personal opinion. I wanted to just throw that out there. When I go into a separate caucus, and this is for both sides, same thing, you're going to hear the same thing every time, and that is, I want people to be prepared. I want people to know their case. And if we have had good pre-mediation caucus meetings telephonically, then the issue of emotion that I referenced earlier will be lessened, and we can get into the focus of the law and the facts of the case. and discuss the deposition testimony and the documents that have been produced and how they impact the law as applied. My feeling is the more detail and more discussion there is on those subjects, it's easier to focus the parties on what the risk analysis is, and it allows you then to focus on things like the venue. And as in these private caucuses, have you discussed with everybody the jury pool and the prior verdicts out of that venue? Have you discussed the judge and the attitudes of that judge and how he or she has approved prior cases? Have you reviewed past rulings on the similar legal issues? And I demand that, and this is really important, that the parties discuss these things with straight honesty. The more honest the parties are, you will be surprised how much common agreement there is in both rooms. And it's only when someone is not being intellectually honest where you have these big chasms and big discords. So then the last part about it is, do we want to have, is there any benefit to separate conversations with counsel? Is there any benefit to having a separate conversation with the mediator and just the client? It's a very touchy issue. It's very undetermined. It's more of a gut, but these are things that we are thinking about at all times, because all we're concentrating on is building bridges and trying to ultimately get the parties to a point where they're in a position to resolve their case. Rod?
And what's interesting, Steve, on this, and staying with the separate caucuses and joint caucuses, there's a right time to bring the right people together for the right issues. And people call them opening sessions. If we call them joint sessions at the right time, we may not need it in the beginning, but at some point during the day, whether it's before lunch, after lunch, before dinner, after dinner, there are a number of different caucuses that come to bear. A, is it just attorneys? B, do you need to bring some parties together? When I talk about parties, I don't mean about the consumer plaintiff. I'm talking about the idea of having in-house counsel involved. Yesterday, without getting into who it was or what it was, a very, very well done class action mediation. And at different times, we brought different people together. And you know what? And when they went back in the separate rooms, hey, those people are pretty nice people. And it was by bringing people together that you got to find out not just that they have titles, whether it's plaintiff attorney, defense attorney, in-house counsel, outside counsel, CFO, CEO, they're people. And it helps build the bridge that we're talking about by bringing them together at the right time and the right way. Now, we defer to counsel. You're the leadership we look for, and we want to build with your leadership. And sometimes you say, hey, we don't need to have anybody else in the room, just us. That's fine. But let's always be open to those other possibilities. And hopefully we can either get it resolved, or most of the times with class actions, especially those that are fairly intricate, what kind of progress do we make so that blends into, all right, what's going to happen after mediation? What's the synergy? You've got synergy that day, whether you work till 4 o'clock, 6 o'clock, 10 o'clock. You've got synergy that occurred, or hopefully you've got momentum. Now, sometimes people say, you know what, got to get away from the table, no momentum, I'm a little frustrated. That's okay. Frustration is a good medicine, because from frustration, if anybody's woke up in the morning and your room was a little messy, you get a little frustrated, you take care of that room, you get it taken care of, you feel a lot better. Same thing with a mediation. We don't get all the issues done, a little frustration, what can we do about it? And it's our job as mediators to keep that momentum going. And so from a post-mediation email to a phone call to perhaps an engagement of meetings thereafter, what's our timeline beyond that mediation? We had a sequencing to get to the mediation. What's the sequencing after the mediation? And if we don't have it, then things just get back into the courtroom. But if we can keep everybody talking, And keep hey, I got to get back on a plane. Give me a couple of days. I got to meet with my people. Okay, fine. Then what about the end of the week? Or what about the following week? Or what can you do at afternoon the day after? It's our job to keep this going. And by the way, confidentiality remains with the process. It doesn't quit at the mediation. It goes on until somebody impasses. As long as nobody wants to impasse it, confidentiality will remain. It also, what I love about post-mediation, strategically, you get opportunities. When we walk out of a room in the mediation and go into the other room, you know where we've come from. You know where the message came from. But when all of a sudden we pick up the telephone and make a phone call, is that because we've been called? Is that because we've called? Is that because we've created a timeline after the mediation? There's a lot of opportunities that post-mediation provides us in not only keeping it going, but keeping the logistical part of it alive. Hey, it's the mediator that's pushing this. It's not perhaps some otherwise interested party. It's the mediator. And that's part of our job, is to keep that neutralized. Steve?
So as Rod just touched on, one of the things that Rod and certainly believes in, and I certainly support, when the case doesn't get done the first time, it ain't over. We're not going to, with the party's permission certainly, just walk away from the case. Many times the case doesn't settle because there's certain things need to get done in the case. People wanted to see where everybody was, but really they want to test and see their summary judgment motion. They want to take the deposition of party A, party B. They want to get some certain rulings from the court. Well, it's our job, Rod and I, or any other mediator, I believe, to monitor that file and check in with the parties, see how the rulings have gone, see how the discovery has gone, gauge the party's interest in reconvening. During the conversations with the parties, with these post-mediation calls, we can discuss the impact of those rulings and the discovery, and see, if you harken back to the discussions we had at the mediation, can we narrow some issues based on the rulings? Continue constantly unpacking the case and define the purpose, so that it allows us to, or allows the parties to continue to reevaluate their case. And with this, the more the rulings and the more the discovery and all those conversations, people constantly reevaluating their case, well, maybe there is a time to reconvene, and hopefully we can encourage the parties to do that.
And of course, from all this, it then blends into, as we talk about the next slide, I think talks about the use of an ethicist. But as I'm hearing Steve, I'm also thinking in terms of, there are other people that are going to play a role in this. Ethicists is one of them. Administrators are others. In the world of mass actions, I spent 4 days working out a mass action of an explosion with almost 500 people hurt, killed, injured, and property damage, and with about 12 different defendants, putting those issues together over 4 days. The beauty of it was, we got to a number. But you want to know something? It was about how to distribute that number. And in a mass action, that's complicated. So was that for the mediator to be a part of allocating where those monies go, or how they go, and how we obtain a globalization of releases? Because the only way that money was going to get on the table was through globalization and releases. No, wasn't the mediator doing that. It required, ethically, it required an administrator. So the suggestion of, okay, here's 2 or 3 administrators, pick one, and go off to the journey of allocating monies and coming up with a process. Interestingly, it ended up in that particular case being a class action process after the mass action was resolved, in terms of getting a global number, understanding the different people we had. It became a matter of getting an administrator, third-party administrator, to assist with the allocation process that could only happen with achieving global releases. And that process Well, it took 4 days for the mediation. That was a piece of cake. It was about a year to get the allocation done. So the use of third-party professionals, and we all know about administrators in terms of administrating the notice and administrating the claims process in a class action, but the use of an ethicist, what could that be about? CAFA notice is an important component to any class action. And if you can get a third party to discuss with both sides, what needs to be done here to protect yourselves, with the court. You're ultimately looking for court approval. So what do we need to do to properly present this to a court? And what are the steps we have to take? Sometimes the use of an ethicist will help guide that. And that becomes, sometimes it's a problem, an issue for the plaintiff. Sometimes it's an issue for everybody. And so everybody joins in on trying to get that third party professional opinion on what needs to be done and how it needs to be done. And the third parties, whether they're ethicists or administrators, help in that regard. Steve?
I don't have anything to add to this particular section, Rod.
With regard to the term sheet, Steve mentioned it before. I think that's our next slide.
We can go there.
And you want to talk about that term sheet? That's an evolving issue, but I think it's one to be addressed now.
Well, yes, and so I believe, and I am sure Rod does, that while we are in the mediation, I think, as I've already said, that the development of a term sheet with all material terms should be worked through. I've developed over the years basically a term sheet outline, and I'm sure most litigants on this webinar have, but I use it because it requires me to not miss any of the elements, and maybe mine's a little more detailed than the parties are willing to go through, but I kind of would like to direct traffic, and anybody is welcome to my outline of this. Just need to ask me post webinar. But in general terms, it starts off with a class definition, and then defining the class, the period, and all the subclasses. There's a discussion of the releases and the form of the releases. There's a discussion of the monetary relief and the non-monetary relief. There's a discussion of cost of notice, cost of administration, payments to the class members. There's a discussion of reverters. There's discussion of cypre. There's discussion of the non-monetary relief, the business practice changes. As we touched on, the administration of the case, the cost of where that's coming from, the form of the notice, how the notice is going to be effectuated. Notice is a big deal in class litigation, as everyone is aware, and sometimes it's a benefit to have already spoken to a notice administrator and have them have given us some ideas on what their thoughts are. A claims process, is it claims made? Is it direct pay? Is it pro rata distribution? What's the tax implications? I want to have a discussion of opt-outs and blow-up provisions and how the parties want to handle that. Or objectors, that's obviously a very big deal in today's world, and how they're going to be handled. And then obviously when all that is said and done, then they turn their attention to the attorney's fees and incentive awards, and where we work through that. And again, we end up with confirmatory discovery and the approval process. So that's my 10 cents on term sheets, but they're very important. I think that the more time spent in the mediation detailing out the term sheets, the easier the settlement agreement is to draft, and ultimately quicker it gets drafted as well.
Well,
Rod?
Steve, you're right, and it doesn't hurt for someone. We all in the world of modern technology, people bring their laptops to the mediation. There's no reason why a term sheet can't be an evolving document. If you work till 10 o'clock at night and all of a sudden you've got to begin doing that term sheet, everybody's fairly exhausted, and does it get the attention it deserves? And Steve is absolutely right. Remember, nothing's agreed till everything's agreed. We got to get it down. Now that we've gotten to this point, is that when we start doing the term sheet, or can it evolve during the course of the day as we knock these things off one at a time? It's not going to be finally agreed till it's all done, but at least that document can evolve. And especially with non-monetary terms, those get to be details that I'm sure on the defense side, that becomes a sensitive issue. You've got competitors out there, and how are competitors going to look at this in addition to the court who's going to approve it? So there's a lot of interests that go into the words that go on a term sheet and giving that attention. Now, does it have to be done that night? No, you can go from general to specific, and it can be an evolving term. The one thing I would say about it, and I just finished, matter of fact, I think it was yesterday, we finally got the finalization of a case that was finally mediated about 3 months ago, but it has evolved with a term sheet that took edit after edit after edit after edit. Appropriately so. It had to happen. And it couldn't happen at that mediation, but it had to evolve afterwards. Now, from the mediator standpoint, what's that sequencing of time? The mediator's role is to continue pushing and prodding. Where are we? What can I do to help? And on your side, again, you finally got to finality. Your clients would like to see this get into the courtroom for approval or whatever the other mechanisms are to get it done. And so the push has got to be continued. The momentum has got to be kept. And of course, in the end of this, you have a term sheet, you put your documents together. What other role is there for the mediator? And what you'll see, after the term sheet, the next slide is the affidavit and or testimony from the mediator. Now, remember, we're neutral, but we are advocates for the process. And as advocates for the process, the idea of giving our statement of arm's length, non-collusive, well thought through negotiations is something that can support the approval process that you'll ultimately go in. So while the mediation can ultimately, okay, we've got our documents, we're conclusive, we're now ready to put documents to publish this to the court, the mediator's role is to be there for an affidavit if needed, not to be imposed, but if needed, if it would be of help. And there have been not a lot of occasions, but over the 26 years I've been doing it, maybe a half a dozen times that I've had to find myself in a courtroom to support the arm's length, non-collusive, well thought through, not only what the negotiations, what led to this, but as importantly, at what point were the attorney fees done? At what point did the incentive award get done? And to be able to say, we worked through all the substantive terms before we had any conversation about. It is said by attorneys on both sides, but from the mediator, it gives another a blessing that can be respected by the court, and certainly can help with those who may otherwise oppose it. But Steve, anything you have to add to that?
Not on that. It just brings us to our last slide, and it's just more of a wrap up. I wanted to just say that, the confirmatory process. What are we thinking about at this point? And as Rod said, is it a declaration from the mediator? Do we also want a declaration from the settlement administrator as to the role that they played, and did they carry out the function in which they were appointed? Any discovery that needs to be done, was it completed so that a final declaration from counsel can be filed with the court, advising the court as to everything they did to fulfill their role and ethical obligations to the class. But with that, Rod, that would conclude my remarks at this point.
Well, I know that we've had some questions that were presented to us before the mediation seminar this morning, and maybe we could address some of those.
Sure. Yes,
Steve.
And Rod and Steve, thank you. Thank you both for sharing your vast knowledge on these matters. And we do have several questions, and we have a few minutes left for that. So our first question is from Jupiter, Florida, one of our attendees. What are the practical and legal restrictions, if any, of class actions against governmental entities such as counties? Steve?
So I'll take this one. I've had the opportunity to be on the both ends of this type of a case. And so the sovereign immunity issues are still there. You have to strategically attempt to plead around them, and it's very hard. My personal opinion is that generally it's not worth it because it's just very, very difficult. The biggest exception to this is civil rights cases. And certainly if there's a civil rights violation, you can plead around it. And but there's a myriad of other problems with regard to Rule 23 that apply. But the analysis still is available. The Rule 23 analysis is still available, but very, very difficult to ultimately get a case against a county or the state in this regard.
Okay, well, our next question is all the way from Philadelphia. For class action mediations, do the presenters believe it necessary for the plaintiff class representative to attend the mediation?
That's a very good question, and the answer depends on the issues. And if there's an issue, is this a class action or an individual action? You will usually hear the defendant say, we want the plaintiff there. If the court orders, and under court rules generally or specifically a court orders it, then unless otherwise excused, they're going to have to be there. From a practical standpoint, they don't necessarily lend to the issues involved. They're more than welcome to be there. Sometimes a plaintiff's lawyer will want them there to, make sure the client appreciates what's been going on. So that too, I'll call that an exception. I would say the overwhelming majority of the class actions that we do, whether they get excused by court order or by agreement between the attorneys, the class representatives do not need to be there. Yes, there's going to be an incentive war that's going to be discussed towards the end, and that is usually not the most difficult issue to deal with, so that can be done by phone. But I would say as a general rule, so long as the court has not required or will otherwise excuse, so long as there's an agreement between the parties, I don't see it's helpful for the representatives to be there. I'm going to go to mass actions just a minute because I'll never forget the particular case I had was a jail happened to have an explosion involved, and we had both inmates as well as guards who were the subject of this. And yes, some were making phone calls and some were attending because they got out of jail. But the point is, they didn't need to be there. That was for the attorneys, for the in-house counsel, for the adjusters, and the coverage counsel for the various insurance companies to be there in focus. And the individuals just would not help in a mass action, and as I said, in a class action.
So how often do mediations arise from class and mass actions? And this question is from Altamont Springs, Florida.
This is Steve. I'll take this one. And the answer is all the time. They're just like any other civil matter. In a federal system, every case is required to be mediated prior to going to trial. In state court in Florida, every case is required to be mediated. So it just, on the state level, it depends on your state laws, but federally, all cases will be mediated, just like all class actions and mass actions will be mediated, just like any other civil case.
All right, and a question from Miami. Any special handling when the defendant is an agency of the state government?
Yes, I think there is, because the unique entity of a public organization, be it state, local, doesn't really matter. The number one issue of confidentiality, how do we work through that? Number two is the issue of authority, because everybody has a superior. So the idea of coming to the table with the appropriate approvals having been dealt with, and with the understanding that this is going to be confidential, and at the right time we can deal with the exposing of this publicly. Those are parameters that have got to be met. So not that confidentiality isn't in place for all mediations, but when you're dealing with a public entity, special attention. When you're dealing with approval mechanisms, yes, you got a corporation that comes with a CEO or a general counsel, but more importantly, when you've got boards, whether water boards, county boards, city councils, there's got to be a mechanism. And you can, keeping within the context of the confidentiality, you can have a mechanism of getting to that counsel to go public at the right time in the right way, and still preserve all the benefits of the mediation.
All right, thanks. And this question from Mobile, Alabama. How do you feel about going into MDLs versus conducting discovery and or trying your cases individually?
So I'll take this one. This is a very personal decision, and your client needs to be very, very involved in this decision. Sometimes you have no choice and you get sucked into an MDL and you don't have control. You have to actually file papers to actually get out of the MDL and go forward on your own, unless you've pled specifically some state law claims that keep you in state court. But the MDLs are largely controlled by the larger firms, and they traditionally get the appointments to be lead counsel, co-lead counsel. So without really good relationships with those lawyers, the small firms generally will be pushed to the side and have little to no role. I'm happy to discuss my personal feelings more offline, but many, many great trial lawyers have gotten their cases out of MDLs, handled their individual case, and gotten great results for their individual client while the MDL moves forward.
Okay, thanks. And what is your procedure, Rod, will direct this to you. What's your procedure for ensuring that adjusters and parties attending mediations have full settlement authority?
Well, it's a good question from the standpoint of jurisdictions. In some jurisdictions, such as in Florida, we have rules that control that. That is, they have to have the authority, up to the last demand. But the truth of the matter is, not many mediations have the upper echelons of any insurance company, whether it's Lloyd's, State Farm, Allstate, whatever. It doesn't really matter. You have adjusters. You have online, and they've got a job to do. And their job, if we just have an appreciation of those jobs, that is that they have met with their outside counsel, inside counsel, and they've come up with a decision. And they send a delegate to that mediation. Now, yes, the delegate should have the appropriate authority. But the truth of the matter is, we don't control the purse strings, and we don't control those decision makers. Their evaluation of the case is an evaluation between X and Y, and our job is to try to get them to work within that area. And then the question is, from the other side, is it enough? Can they stretch it? And can we have ability to make a phone call to somebody? Does it require a meeting afterwards? But there is a level of pragmatism about those who come and those who are sent and those who send them to effectuate the mediation process in a way that can be successful. Understanding this, that these are journeys. Sometimes these journeys can be a couple hours, can be a couple days, they can be a couple months. But from the standpoint of it's over when it's over, and if we can just be patient with it, we'll get the right people with the right authority at the right time to do the right thing. It should be that day, but that from a practical standpoint, evaluations are made. When I say singularly, they're not made with plaintiffs and defendants in the room together. They're being made with a defendant in the room with their insurance company at the echelons of some entity that creates those decisions. And by the way, sometimes there's a tower of those insurance companies, and we've all been a part of cases, whether they're mass actions, class actions, or otherwise, where that tower has got issues too. And so the idea of the procedure for attending with full authority, who's going to come first, how we're going to do that. I'm going to go back to one thing real quick. That pre-mediation, we've been involved in cases where we literally pre-mediate with a tower of insurance. to make sure they understand the issues and they're working together. Because the more efficient they can be, the better we can negotiate at the table.
And thank you, Rod. I'm going to jump in here and wrap this up. You've been looking at this last slide, which has the CLE information. This has an approved one for 1 hour general credit and 1 hour civil trial certification credit. So please, if you're a Florida attorney, jot down the bar course number 1804266N. That's 1804266N. And finally, we just want to thank you so much for participating today. We are really enjoying presenting this ongoing webinar series with the University of Florida Levin College of Law Institute for Dispute Resolution, and hope you're enjoying it as well. Check in with us to learn about our future webinar offerings, and feel free to email us with your webinar topic suggestions. Our plan is to host a webinar each month, so please watch your inbox for news about our August presentation. And this does conclude our presentation. And thank you, gentlemen. Thank you for those who have joined us today.
Thank you, Jeff.